Hello guys, in this video we are going to discuss a major blow to India's investment landscape. Switzerland, a small but highly influential country in global investment, has suspended India's most favored nation status, MFN status. This design could significantly impact the 100 billion trade and investment relationship between India and Switzerland. Now, what led to this decision? What role did the Supreme Court of India can play or did play it? And most importantly, what does this mean for both countries moving forward in future? So let's try to understand the complexities of this particular topic. Let's try to understand first what is this MFN status is all about and its revocation. See, Switzerland's most favored nation status to India was established under the Double Taxation Avoidance Agreement, DTAA, signed in 1994 with amendments in 2010. And this status allowed smoother trade relation by lowering the tax rates and promoting investments. But as of December 11, 2023, Switzerland decided to revoke this privilege, citing a Supreme Court ruling in India. From Jan 2025, Indian companies operating in Switzerland will face higher taxes, and the same applies to Swiss companies in India as well. So this creates barriers to trade and investment, and that will shake the confidence of investors on both the sides. So let's talk about the Supreme Court ruling that I have mentioned and its impact. See, the turning point here is the 2023 Supreme Court judgment involving the tax dispute between Nestlé, a Swiss multinational company, and the case revolved around the interpretation of the MFN clause, in fact. And the court ruled that MFN clause between two countries is not automatically applied when one country joins the Organization for Economic Cooperation and Development, OECD. For example, if a third country like Lithuania, which later joined the OECD, had a lower tax agreement with India, Switzerland couldn't automatically demand the same benefits without an explicit amendment to India's tax laws. So that's about the ruling. So now why Switzerland reacted strongly? Switzerland interpreted the Supreme Court ruling as a move against the principles of fairness in international agreements. For instance, Swiss companies had been paying a 10% dividend tax in India, but expected it to reduce to by 5% based on India's agreement with other OECD countries. So after the court's decision, this expectation was invalidated. Now, frustrated by the lack of clarity and India's reluctance to amend its tax laws, Switzerland decided to withdraw India's most favored nation status, and that's signaling its displeasure. Now, let's talk about the impact on investments and the trade. See, this decision could have a ripple effect on India's economy. Swiss companies, deterred by higher taxes, might pull back from investing in India now. For context, in March 2024, India signed a 15-year trade and investment agreement with the European Free Trade Association, EFTA, which includes Switzerland also. So this agreement promised 100 billion in investment. That's a target which is now at risk because of this. Additionally, if you see Indian companies operating in Switzerland, especially in sectors like financial services, pharmaceuticals, and IT, will face increased operational cost due to the higher taxes. Let's talk about a case study. This Nestlé's dividend tax dispute. See, Nestlé case highlighted the core issues here. Nestlé, assuming a 5% tax rate, paid dividends accordingly. However, if you see, Indian authorities enforced a 10% rate that led to a legal battle. Now, the High Court sided with Nestlé, but the Supreme Court overturned the decision, reaffirming the 10% rate unless explicit changes were made to the Income Tax Act. So this precedent now affects all Swiss companies operating in India and was a major factor in Switzerland's decision. Now coming to India's response, the strategic response. So now India faces a challenging situation. The Ministry of External Affairs have acknowledged the need to revise the DTAA with Switzerland to restore the confidence. Now, experts are urging the government to adopt a more strategic approach to international treaties, ensuring that domestic tax policies align with global standards to prevent such conflicts in the future. Now, what lies ahead for both nations? See, this move by Switzerland is a wake-up call for India to streamline its tax agreements and ensure a favorable business environment for foreign investors. At the same time, Switzerland risks losing a lucrative market like India, Both countries have strong economic ties, and a resolution will require a mutual cooperation, amendment to the tax treaties, and trust building measures as well. So, the situation which we have now currently underscores the importance of clarity in international agreements and the need for proactive diplomacy. If India want to maintain its appeal as an investment destination, it must address these challenges coming in the future. So the loss of MFN status is very significant, but it also presents an opportunity for India to strengthen its global economic strategies. So let's see how this unfolds in the coming months. And that's about this session, guys. Thank you so much for joining. And what are your thoughts on this development? Share your views in the comment section. So in case if you're looking for any mentorship program for IAS or civil services, you can get in touch with us. The details are given in the description. Go through the description and see the details over there. See you in the next video.